Hello, everyone. Today we are going to review Chapter 3. Chapter 3 looks at the judicial process of health information. So health information contained in the health record serves for a variety of different purposes, both clinical and non-clinical. We have supporting direct patient care, quality improvement activities, public health monitoring, and billing and reimbursement as a few of the clinical and non-clinical purposes. One of the most important purposes of health information contained in the health record is as the legal document recording a particular episode of a patient's care. Because of the myriad of legal protections to which health information is subject to, the disclosure of health information that's contained in the health record may only be made pursuant to the legal authority. Generally, health information may be disclosed only on the patient's written consent pursuant to statutory requirements or on proper legal process. So as mentioned, the health record serves as the legal document of a particular episode of patient care. To understand the role the health record plays in a lawsuit, you first must be familiar with several of the legal terms that are covered with this chapter and within the course that you'll learn throughout the semester. So lawsuits use health records as evidence to support or discredit a party's claim. Evidence is defined as testimony, writings, material objects, or other things presented to prove or disprove a fact. In the context of health information, health records may be used as evidence in civil or criminal court actions or in administrative agency proceedings. Before a party may use the health record as evidence to support or discredit a claim, she must determine whether the evidence is admissible. To be admissible, the evidence must be both pertinent and proper. Now, what is considered pertinent and proper for use by a jury or a judge in reaching a decision is usually governed by rules of evidence. In this context of health records, the applicable rule of evidence is known as the hearsay rule. Hearsay is defined as out-of-court statements that are offered to prove the truth of the matter asserted. Health records are considered hearsay evidence because the healthcare providers, so the doctors, making the statements, that is, in the entries into the record, do not do so in court under oath. The complexity of bringing to court the multitude of healthcare providers who made the entries into a particular health record and the cost that would be associated with doing so make it inevitable that very few providers will actually serve as witnesses in court with regards to a particular health record. If not present in the courtroom, witnesses cannot be subject to cross-examination. The majority of the entries that are made in the health record are not subject to cross-examination and are considered hearsay evidence. Because health records are considered hearsay evidence, they are subject to the hearsay rule. This prohibits their admission into evidence absent an exception to the rule. The most commonly used exception to the rule are the business record exception, which is a subset of that exception significantly governing health records, or an exception governing public or official documents. Under each of these exceptions, the party seeking to admit the health record must meet the foundation and trustworthiness requirements of the exception. A foundation is made by establishing that the record was made and kept in the ordinary course of business at or near the time the event was recorded, and by a person with knowledge of the acts, events, conditions, opinions, or diagnoses appearing in it. After meeting these requirements, the party seeking to introduce the record must then establish the accuracy and trustworthiness of the health record. The party accomplishes these tasks by presenting the custodian of records as a witness to explain record-keeping procedures. Now, the custodian of the record within the HIM realm, that would be either the HIM manager or the HIM director. So the HIM professional acting as the custodian of the record, either the HIM manager or director, must be able to testify as to both the foundation and trustworthiness requirements of the business record exception. To assist in establishing the foundation, the HIM professional must possess knowledge of the requirements to create and maintain a health record issued by governmental entities, accrediting agencies, and internal policies and procedures of the healthcare provider, along with the knowledge of the manner in which data are recorded. To assist in establishing trustworthiness, the HIM professional must possess knowledge of internal policies and procedures governing access to the health record and quality control techniques, such as approved methods to make corrections to and to use abbreviations in the health record. If electronic health records are involved, additional steps are necessary to establish the foundation and trustworthiness requirements. In a typical situation, HIM professionals testify at either a deposition or a trial. In both situations, the HIM professional is placed under oath and they answer a series of questions that are designed to establish the foundation and trustworthiness requirements. If the HIM professional is presented with a subpoena ducis tecum, the HIM professional will present and deliver the original or a copy of the health record to the requesting party, in the case of a deposition, or to the court, which is in the case of a trial. Sample questions presented to the custodian of records may consist of: state your full name and business address. Are you the custodian of records for such and such healthcare organization or healthcare provider? In answering these questions, have you made a full and complete search of the healthcare provider's records for patients XYZ? Have you presented today a true, complete, and accurate copy of all of the healthcare provider's records for patients X, Y, and Z? If not, please state as accurately as possible all such documents that are not presented today and the reasons therefor. Are all entries contained in the health record presented today made by the name of the healthcare provider or her employees in the ordinary course of business? If not, please identify which document or entry presented today is not made in the ordinary course of the name of the healthcare provider's business. What procedures are taken to ensure the accuracy of the records you have presented today? So these are just a few of the sample questions that a custodian of records would be presented with. In addition to overcoming the hearsay rule, a party wishing to admit the health record as evidence must overcome application of the privilege doctrine. Privilege is the legal right to keep certain information confidential and protected from subpoena, discovery, or introduction into evidence at trial. A privilege will be considered waived if the confidentiality is breached either through carelessness or deliberate disclosure by the party holding the privilege. In the context of health information contained in the health record, the most frequently used privilege is the physician-patient privilege. Physician-patient privilege is created by statute and is used to prevent the forced disclosure of or testimony about information obtained by the healthcare provider during the course of treatment. The privilege exists to encourage the patient's disclosure of relevant information to healthcare providers, no matter if that information is of embarrassing or humiliating nature. Privilege is generally held to rest with the patient, but may be asserted on the patient's behalf by the healthcare provider to prevent forced disclosure. The privilege frequently applies in situations in which the healthcare provider is a party to the lawsuit. It generally does not apply in criminal actions which contest and physician licensure proceedings. Whether the healthcare provider should assert the physician-patient privilege is a question to be answered with the assistance of legal counsel. In the context of health information, two other privileges are worth noting. An attorney-client privilege refers to the legal protection of communications between a client and her attorney made in confidence for the purpose of obtaining legal advice. On the other hand, we have a work product privilege, which is sometimes referred to as the work product doctrine. This is referring to materials prepared in anticipation of litigation that may be shielded from discovery. Unlike the attorney-client privilege, the work referred to under the work product privilege is not limited to an attorney's communications, but can include tangible materials prepared by persons other than the attorney. Similar to the concept of privilege, we now have exclusions to discuss. Exclusions operate to prevent admission of evidence in a court case. One such exclusion is the apology of healthcare providers for any unanticipated outcome of the delivery of medical care. These apologies may be contained in the health record or may be separated entirely from the health record. In either instance, the laws of several states may shield the apology from admission into evidence in a medical malpractice case. These laws fall into two categories. The categories being those offering a full apology, both an expression of sympathy and admission of responsibility, and those offering a patient apology, an expression of sympathy alone. For purposes of understanding the role of apologies in litigation, the concept is that an offer of an apology given in a timely manner is going to decrease the number of medical malpractice lawsuits. The general rule of ownership of health information states that the healthcare provider owns the medium in which the health information is stored, the health record, with limited property interest possessed by the patient. From this rule flows the principle that the record must remain within the provider's control and safekeeping and may be removed only in accordance with a proper legal process. Subpoenas, court orders, discovery requests, and warrants constitute proper legal process. When faced with a subpoena, a court order, a discovery request, or a warrant, health information professionals are placed in the difficult position of how are they going to respond. Should they release the requested records? Do they refuse to release the requested records? Or excise those portions of the records that the health information professional determines are protected and release the remainder? Health information professionals, if they fail to respond to the subpoena, court order, discovery request, or warrant, they expose the healthcare provider to potential contempt of court charges. If the HIM professional improperly releases the records, they may then be subjecting the healthcare provider to liability for breach of confidentiality. Only upon a determination that a valid subpoena, court order, discovery request, or warrant has been presented and that a valid legal defense against disclosure does not exist, should the HIM professional then release the requested records. The most common legal process that a healthcare provider will encounter is being served with a subpoena. Now, a subpoena is a command that's issued by a court or another authorized official to appear and or present certain documents and other things. A subpoena commanding the appearance of a witness to give testimony is called subpoena ad testificandum. A subpoena commanding the production of books, documents, and other things is called a subpoena ducis tecum. A subpoena ducis tecum is often used in the context of health information management, commanding the custodian of the record to produce a particular record at a trial or deposition and provide testimony as to the authenticity of the record that's produced. Now, there are certain elements that are common to all valid subpoenas, and common elements are listed here. It includes the name of a court where a lawsuit is brought, name of the parties involved in the lawsuit, the parties being both the plaintiff and the defendant, the docket number of the case, date, time, and place of the requested appearance, specific documents to be produced if a subpoena ducis tecum is involved, the name and phone number of the attorney who requested the subpoena, signature, stamp, or a seal of the official empowered to issue the subpoena, and witness fees where provided by law. On this slide right here, an example of a subpoena ducis tecum in a civil case that's being brought in a federal court is illustrated. In addition to subpoenas, HIM professionals may be presented with court orders authorizing the disclosure of patient-specific health information. A court order differs from a subpoena in that the court order authorizes the disclosure that would otherwise be prohibited by statute and regulation. A subpoena cannot authorize disclosure that would otherwise be prohibited by statute and regulation. A subpoena is subject to any and all legal defenses created by statute, regulation, and common law. The method used to apply for a court order authorizing the disclosure is subject to regulations and rules of court and may vary by jurisdiction. A variation of a court order is a show cause order. A show cause order is a court decree directing a person or an organization to appear in court and explain why the court should not take a proposed action. If the person or organization fails to appear or sufficiently persuade the court to take no action, the court will then take the action originally proposed. In the health information context, show cause orders may be issued in the event of no response to the subpoena or court order that was originally issued. In addition to the request for health information that's made through subpoenas and court orders, the discovery process will involve the health information professional in responding to requests for health information. Discovery requests include methods described in the table in your textbooks entitled Methods of Discovery. Methods of discovery include depositions, interrogations, production of documents, and physical or medical examination. The Federal Rules of Civil Procedure govern all forms of discovery conducted in proceedings filed in federal court. Back in 2006, the federal judiciary revised the Rules of Civil Procedure to specifically address discovery and production of electronically stored information, also known as ESI. Electronically stored information, the ESI, refers to a distinct category of information that includes emails, web pages, word processing files, databases storing memory of computers, magnetic disks, optical disk, flash memory, and even backup media. The discovery process involving the electronically stored information is commonly referred to as e-discovery. E-discovery impacts the electronic health record, particularly related to preserving data and records. Electronically stored information is unique because it has raised significant issues that are generally not present when conventional paper-based information is disclosed as part of the discovery processes. Special challenges have arose because of the dynamic and changeability of electronic data. The space and storage may be limited due to data storage. The data may also be overwritten or deleted, and destruction may be done in the ordinary course of business based on policies and procedures. There is a need to preserve information that must be balanced with the need to conduct business, and e-discovery rules are designed to address special challenges. Now, litigation hold we had discussed last week when we reviewed Chapter 2 in the text, the Court Systems and Legal Procedures. Just as a refresher, litigation hold refers to the actions of a party who possesses data to make efforts to prevent routine destruction and preserve the electronically stored information that may be discoverable even before the time when a lawsuit is filed. Okay? The opposing party may trigger this duty by advising that he may intend to file a lawsuit or by sending a notice of preservation. An order of preservation is a court order that requires a party to preserve electronic and other evidence regardless of the party's need to engage in routine deletion or destruction practices and procedures. An order of preservation is a type of temporary in nature, meaning that at some future date, that temporary order will be lifted and the opposing party may then go on to resume their ordinary computer deletion and destruction practices and procedures. Spoliation is another significant issue that's related to e-discovery. Spoliation refers to the wrongful destruction or material alteration of evidence or failure to preserve property or data for another's use of evidence in pending or reasonably foreseeable litigation. In many respects, it's opposite of preservation. The central question of spoliation is whether the party who destroyed or altered the evidence had reason to know not to do so. There are many different issues that impact healthcare data. It requires maintenance of policies and procedures that cover the production of discovery material. In policies and procedures, it will be outlined what exactly to hold or preserve, how to monitor the hold or preservation, and how to produce electronic health records. In nature, electronically stored information is dynamic and is changeable. Routine computer operations that are critical to a healthcare organization's day-to-day operations and activities and the limitations that are faced by electronic storage memory drives may require those healthcare parties to actually overwrite data. Emails may be regularly deleted or backup tapes may be recycled as part of the organization's regular business practices. Destruction of data and records may be performed in the ordinary course of business, and for these reasons, the need to preserve information is always balanced against the need to continue routine operations that are critical to a party's day-to-day business activities. On rare occasions, HIM professionals will be faced with a demand for a property and information by a law enforcement officer that seeks to execute a warrant. A warrant is referring to a court's prior permission for that police to search and seize property or information. Police officers that are seeking a warrant must provide a judge detailed characteristics of the property or information they seek and the reasons supporting their request. Warrants are issued if the detailed characteristics and reasons indicates probable cause. Probable cause is a belief that based on specific facts that a crime has been or is about to be committed. Warrants are time sensitive. Warrants must be executed and carried out within a specified time period. As a general rule, police officers must announce themselves as police and execute the warrant during the daytime unless the warrant specifically allows other arrangements. Police officers must inventory and describe in writing all the items that they seize and usually provide in a receipt to the suspect. Under special circumstances, permits may be permitted to police that execute a warrant without announcing their presence in advance. This is referred to as a no-knock warrant. A no-knock warrant applies to situations where the evidence is likely to be destroyed or the police administering the warrant will be in danger. The law does permit searches without a warrant under time-sensitive or emergency conditions. This is referred to as exigent circumstances. For example, if police officers believe evidence will be destroyed, or if the officers wait for the court to issue a warrant, they may act without one. Similarly, the plain view doctrine permits searches without a warrant if the suspect leaves an item where it is openly visible in an area where officers are authorized to be. Officers are then not required to wait for the courts to issue a warrant before acting to seize the evidence. Prior to ever being presented with a subpoena, a court order, or a discovery request, HIM professionals should have in place a litigation response plan. Now, a litigation response plan is a tool that consists of policies and procedures that address how to respond to a legal process request. The plan should be developed with the advice of healthcare providers' legal counsel and should address the division of labor between the HIM professionals, counsel, and other members of the healthcare team. In matters that involved e-discovery, it is helpful to create a litigation response team where the team consists of healthcare providers' legal counsel, senior management of the healthcare organization, and health information management professionals, as well as information technology professionals. It's going to be important that components of electronically stored information is clarified, and this is going to look at the forms, format, and data of the records, and it's going to be important to deal with any issues around cost, storage, location, and that production of electronically stored information. Then you will be able to determine the measures that are needed to take to preserve and search for electronically stored information. HIM professionals should not automatically assume that every discovery request or subpoena that's presented requires the release of information requested. If such an assumption is made and information release is subject to a valid legal defense, such as the physician-patient privilege, health information professionals are subjecting the healthcare provider to potential liability for the improper release of records. The HIM professional should first determine whether subpoenas issued in her particular jurisdiction also require valid written consent given by the patient before a release is made. The HIM professional should also determine whether the health information that's requested involves treatment for substance abuse, mental health, genetic testing information, or any other sensitive health information. At times, an HIM professional may actually find that responding to a subpoena would be unreasonable, oppressive, or may call for privileged documents. In those instances, HIM professionals may go and consult a legal counsel to determine if a motion to quash is in order. A motion to quash is an approved method to challenge the validity of a subpoena ducis tecum. This motion requests a court to examine the subpoena to determine whether the person who is the subject of the subpoena, here the HIM professional, must produce the documents in question or can legally, without some or all of the documents sought by the subpoena. At no time should an HIM professional ever ignore the discovery request or a subpoena. There are substantial penalties that do exist for failing to respond to discovery or failing to obey a subpoena, and this includes fines as well as court proceedings. If an HIM professional questions the validity of the discovery request or the subpoena, or whether it should be honored, they should definitely consult with the healthcare provider's legal counsel to determine how to proceed. At this time, we have completed our presentation on Chapter 3, the judicial process of health information. I do encourage everyone to review their textbook for this chapter, as well as the learning module that has been posted, and to take a look at the discussion board or case study posted for this week. If you have any questions at all, please feel free to reach out and I am more than happy to help. Thank you.